Hello, welcome to this UKLFI Charitable Trust webinar on the new ICJ advisory opinion being sought on Israel. Will it help or hinder peace? Well, in one of the latest lawfare initiatives against Israel in December 2022, the General Assembly requested an advisory opinion from the International Court of Justice in Resolution 77247. That resolution and the documents it cites make many allegations against Israel, which are partisan, incorrect, distorted, without context, and which continue to build upon the abuses and misrepresentations of international law with which we have become familiar. But in truly unparalleled fashion, the questions asked by the General Assembly presume facts and legal conclusions that are simply incorrect. For example, the court is asked, what are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination, from its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, and from its adoption of related discriminatory legislation and measures? Well, I'm delighted to be joined to discuss these developments by Professor Orde Kittrie, a leading expert on international law, particularly as it relates to the Middle East, a senior fellow at the Foundation for Defense of Democracies and professor of law at Arizona State University. He's previously served in legal and policy positions at the US Department of State, helping to negotiate 5 US-Russia nuclear agreements and a UN treaty to combat nuclear terrorism. Professor Kittrie is the author of Lawfare, Law as a Weapon of War. And in August, the US Military Academy, West Point, published an article by him entitled The Pending Israel-Palestine ICJ Advisory Opinion, Threats to Legal Principles and Security. Orde, it's wonderful to have you with us. You wrote in this West Point article that the ICJ is poised to eviscerate the long-standing Land for Peace legal framework for resolving the Israeli-Palestinian conflict set down in many UN Security Council resolutions and, of course, the Oslo Accords. Could you give us your experience as a lawyer and a negotiator on this development?
Sure, it's my pleasure. UKLFI does such important work in this space. I'm always glad to chat with it and its supporters. As Natasha mentioned, the ICJ is poised to eviscerate that long-standing Land for Peace legal framework. The Land for Peace framework means that Israel need not withdraw from the disputed territories unless the Palestinians and other Arabs deliver peace in return. As Natasha mentioned, it's the only framework for achieving peace that has been endorsed by Israel and all Arab League member states. Yet the ICJ, the International Court of Justice, at the behest of the UN General Assembly, is very likely to soon opine incorrectly that international law requires Israel to unilaterally and unconditionally withdraw from the disputed Palestinian territories. In other words, the ICJ is on the brink of announcing that the Land for Peace framework is inconsistent with international law, that Israel cannot wait until the Palestinians and other Arabs deliver peace in return, but must instead evacuate the territories immediately. This is a very problematic development. I'll start my presentation with a bit of a background about the ICJ and why this case is so dangerous. Then I'll describe how things got to this point, where they stand procedurally, and what can be done. After about 20 minutes, I'll round up and look forward to your questions on this topic. So what is the International Court of Justice? Some of you may know, others not. The International Court of Justice is the principal judicial body of the United Nations. It was established in 1945 by the Charter of the United Nations. The seat of the ICJ is in The Hague, the Netherlands. Thus, the ICJ is sometimes referred to as The Hague. The ICJ's role is to settle, in accordance with international law, legal disputes submitted to it willingly by states. That's its primary jurisdiction, to settle legal disputes submitted to it willingly by states. But it also, and that's what it's doing here, has the authority to give advisory opinions on legal questions referred to it by authorized UN organs and specialized agencies, such as the UN General Assembly. Who sits on the ICJ? The ICJ is composed of 15 judges who are elected for terms of office of 9 years by the UN General Assembly and the Security Council. Each is a national of a different country. In the past, the UK had a judge who was a UK national, Rosalind Higgins, who some of you may know, but the UK does not currently have a judge on the court. One currently is an American. There's also a Frenchman, a German, and an Australian. While the ICJ may be relatively unknown outside legal circles, its opinions carry a lot of weight, and that's why this case is so important. The last time the ICJ addressed the Israel-Palestine conflict was in 2004, when the ICJ opined in what is commonly referred to as the wall case that Israel's security wall and settlements are illegal. That has helped power the BDS movement, and it's very heavily influenced the international community's view that the settlements are illegal. Every time an advocate sympathetic to Israel tries to argue that the settlements are legal, we get shot down with the argument, no. In 2004, the ICJ, by a vote of 14-1, only the American opposed, opined that the settlements are illegal. So the pending case before the ICJ, which we're discussing here today, is designed by its proponents to build on that wall case from 19-20 years ago. The pending case is called Legal Consequences Arising from the Policies and Practices of Israel in the Occupied Palestinian Territory, including East Jerusalem. The pending case was carefully designed by Israel's enemies to box the ICJ into an opinion that, as I said before, international law requires Israel to unilaterally and unconditionally withdraw from the disputed territories. In my assessment, the ICJ is in fact likely to reach such a conclusion unless key countries such as the US, UK, etc., push back hard. Now, what would be the consequences of such an opinion? An ICJ opinion that international law requires Israel to withdraw from the disputed territories without any Palestinian concessions on any of the permanent status issues would empower extremists, frankly, on both sides of the conflict. Such an opinion would make it far more difficult or even impossible for Palestinian leaders to compromise with Israel on such issues. In addition, for the ICJ to treat Israel as if Israel has annexed the disputed territories, when Israel has not, in fact, annexed the disputed territories, seems likely to encourage Israeli extremists, including some members of the current government, to urge that government to proceed with annexation. They will say, if we're being treated as if we have been annexed, well, why don't we just go ahead and annex? What they certainly won't do, what the Israeli government certainly won't do, is agree to unilaterally withdraw from the West Bank. I probably don't need to remind you why that is, but key facts that I emphasize in my study: Israel's presence in the West Bank has enabled it to keep to a total of about 5 the number of rockets fired into Israel from the West Bank since 2005. In contrast, over 20,000 rockets have been launched at Israel from the Gaza Strip since Israel's withdrawal from Gaza in 2005. The West Bank, unlike the Gaza Strip, is located very close to Israel's largest population centers. A Gaza-like rocket threat from the West Bank in the wake of an Israeli withdrawal would put many Israelis in grave danger and would likely shut down Israel's economy and society. So Israel will inevitably decline to unilaterally withdraw. As a result, the advisory opinion will, in addition to undercutting compromise-minded Palestinians, it'll create yet another Israeli quote-unquote violation with which activists can demand anti-Israel boycotts, divestment, and sanctions. Given the practical realities, I think that's the real objective of the architects of the current case before the ICJ. So that's the risk posed by the current case before the ICJ. I think it's worth talking a little bit about how we got here and where things stand procedurally, so we can then focus on how to respond. So how did we get here? The UN General Assembly initiated the case by a resolution passed on December 30th, 2022, that requested an ICJ advisory opinion on two questions relating to the legal status and consequences of Israel's presence in the occupied territories. Where did the idea for that question posed by the UNGA to the ICJ come from? Well, it came from that controversial UN Commission of Inquiry involving Navi Pillai and others. That Commission of Inquiry has been investigating the Israeli-Palestinian conflict. It had recommended in an October 2022 report that the UN General Assembly request such an opinion, and lo and behold, 2 months later, the General Assembly requested such an opinion. To be specific, the Commission of Inquiry set forth, quote, grounds to conclude that the Israeli occupation of Palestinian territory is now unlawful under international law. The Commission of Inquiry argued that the Israeli presence in the West Bank may not have been illegal originally, but has become illegal as a result of Israel's construction of settlements and a separation barrier. The Commission of Inquiry concluded that these developments amount to de facto annexation of occupied territory, and then the UN General Assembly request to the ICJ is designed to elicit an advisory opinion echoing that COI conclusion. So the COI says, well, we think the Israeli occupation has now become illegal. General Assembly, why don't you ask the ICJ the question of whether it's become illegal? The General Assembly, led by the Palestinians, posed the question in a very, very narrow way, virtually assuring the result. The passage of the resolution was actually relatively close. It's worth mentioning. It passed by a mere plurality, well short of a majority of the UN's 193 member states. Key countries joining the US and Israel in voting against the UN General Assembly request to the ICJ for this case. Key countries included Australia, Canada, Germany, Italy, and the United Kingdom, all opposed the UN General Assembly posing this question, but all you need is a plurality, and a plurality they got. So the case is now pending before the ICJ. Interested governments have 3 opportunities to submit their views. The first round of submissions was filed on July 25th. Those states that submitted in the first round will then have until October 25th to submit written comments on the written statements made by others in the first round. And then oral proceedings are planned for early 2024. And it looks like we will probably get a decision in this case in the middle of 2024. Is this case a lost cause? I think not. If you do the math as to where the judges are from, there's some reason for optimism. If the UK, US, and like-minded allies submit a robust set of briefs, seems to me they could impact the case's outcome. Of the 15 ICJ judges, 8 are from countries that either voted against the resolution or abstained, right? 8 of the judges, 8 of the 15 are from countries that either voted against the resolution or abstained. It's the US, Australia, Brazil, France, Germany, India, Japan, and Slovakia. Now, judges do not represent their home countries, and they're required to be impartial. But studies show that judges' perspectives typically reflect the fundamental values and often, frankly, the specific submissions of their home states. So as I mentioned, there was a first round of submissions due July 25th. So what happened in that first round of submissions? Well, the court reported that it received 57 written statements in the first round from 54 listed countries, including the UK, the other permanent members of the UN Security Council in Israel. And there were also 3 intergovernmental organizations that were given special permission to submit: the African Union, the Arab League, and the Organization of Islamic Cooperation. Now, there's less transparency than we might want in this case. The ICJ is actually refraining from publishing the written submissions until the oral proceedings. So we know that there were 57 submissions. We, generally speaking, don't know exactly what they said. I said generally speaking because several submissions, including those of Canada and Ireland, have leaked in full. In August, The Guardian reported that it had seen the UK's first round submission and provided a brief summary of it. It may be that a number of you saw that article, but I'll just sort of draw attention to the article's bottom line. The Guardian reported that the UK brief submitted to the ICJ rests on 4 main arguments. The first, an advisory opinion would conflict with existing agreements between the parties and negotiation frameworks endorsed by the UN. That's a reference to what I talked about earlier, that an advisory opinion could well conflict with the Oslo Accords, the UN 242 Land for Peace framework, etc. Another point was that, which the Guardian reported, was in the UK brief. And I'm going through these because from my understanding of the case, the Guardian's list sounds accurate. And my understanding of the case is, of course, based on discussions with other countries, including the US, and reading the Canadian brief and the Irish brief and the others that have leaked. So the second UK point is that an advisory opinion would effectively settle Israel's bilateral dispute without the state's consent, right? This is the point that I made earlier, that the ICJ is really supposed to settle disputes between states which willingly submit those disputes to the ICJ. Here, Israel is not willing to have its dispute with the Palestinians decided by the ICJ, so there was a runaround, which was basically to have the UN General Assembly pose a question. And that is why this is an advisory opinion and not a quote unquote binding. But anyway, the UK government objected, I think rightly, to that as a kind of circumvention of Israel's sovereignty. Another point that the UK reportedly made is that the request is not appropriate, as it asks the court to, quote, assume unlawful conduct on the part of Israel. Very correct. The questions are totally biased, as was mentioned by Natasha. They really try to box the ICJ into a corner. It doesn't allow them to do their own fact-finding, but basically forces them to operate on the basis of assumptions foisted on them by the UN General Assembly request. And the final prong of the UK submission, according to The Guardian, is that the court is not equipped to examine a broad range of complex factual issues concerning the entire history of the parties' dispute. I think that's a reasonably good point as well. As a result of the Guardian article, the UK government has been heavily criticized for quote unquote, taking Israel's side in the case, and has been urged not to again take Israel's side in the subsequent rounds of the case. It's been criticized, obviously, by the pro-Palestinian community. It's worth noting that a very similar dynamic played out in Canada in August. The Canadian government submitted a brief in this same case, which was fully leaked and harshly criticized by Israel's opponents. I worked closely on a response to that leak with Irwin Cotler, the eminent former Justice Minister and Attorney General of Canada. Irwin and I published an op-ed on August 27th in a Canadian newspaper, which defended the Canadian brief, explaining why it was the right thing to do and urging Canada to go further in the subsequent rounds. Irwin also arranged for me to address a coalition of the 3 leading Canadian Jewish organizations, which subsequently supported the Canadian brief both publicly and in a private letter to the Canadian Prime Minister and Foreign Minister. It's our understanding that that support was very much welcomed by the government of Canada. They appreciated the support for what they have had done, and that support has really made it easier for them to continue doing the right thing. Erwin and I are also reaching out to the French Jewish community. In addition, since I'm a former U.S. State Department attorney, I've obviously been in close touch with the U.S. team at the ICJ. And all of these outreach efforts, our goal is the following: to increase the number of judges who do the right thing in the case. The Wall case was lost by 14-1. It's essential that as many judges as possible vote the right way on this case. We believe that the pivotal judges are most likely to be influenced by the arguments of key governments friendly to theirs. It appears that at least the US, Canada, and UK are on the right side of this case, but we'd like to see them do more. Particularly in this next round, the October 25th round, I've been told that the Palestinian submission is over 300 pages long and was very, very well done. They obviously involved some top flight lawyers. And for the US, Canada, the UK, and others to have a maximal impact on this case, they're not only going to have to say what they think, but they're going to need to take on and attempt to demolish the Palestinian case. A robust initiative in this next round would involve robustly coordinating with each other, both their briefs and their efforts to influence and respond to other briefs. We believe that political motivation is a key to that, that these governments are relatively inclined to do the right thing, but as with Canada, I think it's important to thank them for what they've done thus far and encourage them to do more. We also believe that based on our discussions with key players in this case, that one of the biggest obstacles to victory for our side, or a relatively less bad outcome in this case, is a misunderstanding that Western interests in this case are limited to defending Israel, whose current government and policies regarding the territories are highly controversial. We think this is a misunderstanding of what this case is about, and it's also a losing framework. We've been told repeatedly, if this case is about defending the Netanyahu government, countries aren't going to be very excited about it. You have to explain why this case is about larger issues. So my own writing and advocacy has focused on explaining that the Western allies, in fact, have their own additional fundamental national security interests at stake. I'm going to go through those very briefly, and then I'll open things up to Q&A. As my article West Point argues, as my article with Erwin argues, the ICJ in this case is not only at risk of eviscerating the sole agreed framework for achieving Israeli-Palestinian peace, but it also risks undercutting the inherent right of states to self-defense and sovereignty. It risks undermining the UN Security Council's authority to maintain international peace and security, and it also risks subverting the law of armed conflict. I'm happy to discuss those all further during Q&A. I hope you found this to be a useful overview. I look forward to your questions.
Orde, thank you very much indeed. That's certainly been a very useful overview. There are already questions coming into the Q&A facility in Zoom, and I would encourage our audience members to continue placing their questions into the Q&A tab. I'd also mention that the two articles that you've referenced, both your article with Professor Noam Kotler and your article with Bruce Raskov, are also posted in the chat, so our audience have links to those. Could I pick up in the first instance on your comparison of this advisory opinion with the 2004 so-called Wall opinion? And the very different approach taken, for example, by the Israeli Supreme Court in the Beit Sarit case. The Supreme Court in Israel, in fact, compared the factual bases upon which it, in that previous case, was able to make an assessment of the security barrier as against the position that the ICJ found itself in. And there's certainly a lot to be said. You've mentioned the court's fact-finding operation with respect to the requests that have been made of it now. The quality of the information before the court, both in 2003, 2004, and today. Do you think that based on the information the court has before it, it is in a position to answer the questions in any meaningful way?
So I think no. I mean, look, my view, as is the view of the U.S. government, if you were to see their brief, and obviously the view of the UK government, is that the ICJ should decline this case. Unfortunately, I think the chances that they decline this case are very slim. They didn't decline the Wall case, and I think that is the key precedent to look at. I think that they are going to take this case on. The question is, what is the best way of influencing the result? It's basically how many judges can you persuade, how many governments can you get to weigh in with the judges to persuade them that they should not eviscerate the Land for Peace legal framework by arguing that Israel is illegally occupying the West Bank. It's worth noting that in the Wall case was really a very poorly reasoned case. The judges in that case went out of their way to avoid grappling with the facts, and they were actually criticized for this by the U.S. judge at the time, Thomas Bergenthal. The ICJ majority in the Wall advisory opinion decided that Israel could not claim a right of self-defense when facing attacks by terrorist groups rather than by national governments, or attacks which originated from territory over which Israel had some control. This was, from a legal perspective, relatively preposterous. It certainly ran up against the experience of many Western states, which like to exercise self-defense against terrorist groups, including when those terrorist groups originate from territory over which they have some control. Why did the ICJ majority take this approach? Well, they didn't want to grapple with facts demonstrating how the Wall mitigated threats to Israeli security. And here again, there's going to be a temptation to say, oh no, Israel doesn't have a right of self-defense. This isn't about Israel's right of self-defense. Self-defense isn't a defense to Israel's occupation. Israel needs to get out. And one of the points that I make in my West Point article is that a decision like that by the court would cause problems not only for Israel, but also for the US, for the UK, for India, and many other countries. So a big part of what we're trying to do is explain to governments like that of the UK and India and France and others, you have your own ox being gored here. This is not just about it. Whether or not you like the current Israeli government, a bad decision hostile to Israel here will hurt your interests that have nothing to do with Israel. And we believe that that's a helpful set of arguments to make, to both make the point that this, the way this case is heading is bad for Israel, but also that it could well cause problems totally separate and aside from the Israel situation for the UK, India, the US, etc.
And of course, that ties in with all of the damage being done to international law through the politicization of these initiatives and the driving of this agenda through these international legal institutions. Taking on board the political context then, as well as the legal institution that's been tasked with this opinion, one of our questioners asked, do you think that the Palestinian Authority and other Palestinian organizations are already inciting violence in the hope that this may encourage the ICJ to deliver a substantive opinion? Any thoughts on whether the worsening political context, perhaps, and the uptick in terrorism may be having an impact on that?
So it's clear, you know, I don't have sort of intelligence as to whether the PA is, encouraging violence in order to sort of help themselves win this case. I think they're trying very hard to win this case. They've hired, obviously, some very capable attorneys. They're putting a lot of diplomatic resources into attempting to win this case. I would say that this case, indeed, it's important to note that at the time of the Wall case, the US response and the UK response, et cetera, was to say, look, ICJ, please stay out of the Israel-Palestinian conflict because we have the roadmap for peace. We have a peace process ongoing. So please stay out of it. The ICJ, nevertheless, butted in and came up with its conclusions. There is no Israeli-Palestinian peace process going on now. And I think that makes it easier for the ICJ to say, look, well, you ask us to defer to a peace process, which is moribund. We're not going to do that. It seems to me also, frankly, that the policies of the current Israeli government, I have been told, I won't mention which governments, but there are certain governments that could have submitted in this round, right? You'll see there are 54 countries that submitted. There are some countries which didn't submit. And if you ask quietly why they didn't submit, it's because they were really annoyed at the Israeli government. They might have submitted under a different government, or might have submitted if there were an Israeli government that appeared to be, in their view, more committed to the peace process. So this is a difficult environment for Israel and its allies to win this case, both because the peace process is moribund and because the current government, more so than any previous government, is seen as engaging in creeping annexation, which is really what the other side is trying to make this case about.
And that's a stark reminder that the current divisions that we're seeing are harming Israel, perhaps in more ways than may be immediately apparent. So thank you for that. Or there are a couple of questions about approaches, both by Israel and international supporters of Israel, in 2004 and today. One asks that in the 2004 proceedings, Israel, it notes, submitted briefs which argue that the ICJ lacked jurisdiction, and when those arguments were overruled, Israel elected not to participate in the substantive proceedings and protests. So the question asks, at first, was that a wise approach, do you think, in 2004? And what might the takeaways be from that advisory opinion, whether Israel should participate in the proceedings here on the merits, or, like it did in 2004, opt out in protest?
So that is a very good question and a very important question. Here, Israel also, my understanding is that Israel made a 4-page submission, basically saying, the ICJ has no business being involved in this case. Okay, they did not address the merits. I don't know what they're planning to do in the October 25th round. I'm not sure even they know what they're going to do in the October 25th round. Israel again and again is faced with the question in these proceedings: if you participate and you lose, your participation has legitimized the process. On the other hand, if you don't participate, are your arguments going to get in front of the court? And so how does Israel Israel and supporters try to get around that? Well, obviously, Israel has allies like the US and the UK and Canada that are making some arguments, but there are arguments that Israel could make might make that the US and Canada, UK won't make, right? And at the same time, you have outsiders, organizations such as B'nai B'rith or the World Jewish Congress or UKLFI that might weigh in. The ICJ does not have as, shall we say, robust an amicus type of process as other cases do. There is a procedure for making submissions. They're not quite as central to the proceedings as they might be in other cases, such as the International Criminal Court. But it's certainly important to make those arguments, for somebody to make those arguments. The question is how to get them in front of the judges. The judges aren't required to look at them, but one hopes that they will. I can tell you that before I published my article, I shared it with the US government well ahead of their submission of their brief, and I have reason to believe that some of its arguments were reflected therein. So I would encourage anyone who is sort of making a full case and an amicus brief to both publish it, get it on the record, but also find various ways of getting it into, shall we say, the bloodstream of, sharing it with governments, writing it up in op-eds, which are maybe more digestible than a 80-page brief or whatever, and thinking about, again, this really comes down to probably 8 judges. And the question is how to influence them. And if you have arguments in your brief that might impress an Indian judge, think about ways of getting those arguments in front of an Indian judge. You have an Indian lawyer that you can co-author an op-ed with, for example, in an Indian paper that the Indian judge might be sure to read.
But I can certainly hopefully give you some encouragement and comfort that UKLFI has, of course, been working on a submission, as it did submit an amicus brief to the International Criminal Court, which elicited quite a substantive response, actually, from the prosecutor in that case, and is careful to be making the arguments that we anticipate states may not necessarily be raising. Orde, you've answered a couple of additional questions, including what ordinary what private attorneys can be doing to support a positive outcome. And then, of course, in addition to op-eds and articles of their own initiative, lawyers and ordinary citizens, perhaps the UK, can be encouraging the government, while that submission remains unpublished, harder, except on the basis of what the Guardian has leaked, but certainly voicing its support for that initiative. On the UK, you've mentioned the interests of Western allies and their own interests, national security interests within the law of armed conflict, also potentially being impacted by a problematic or politicized advisory opinion. But a couple of questioners have asked for some more detail. Could you give some examples of where the UK might see its own national security interests particularly being affected by the sort of opinion that Israel's detractors are seeking?
Absolutely. So as I mentioned, in order to evade Israel's claim that, hey, this wall is about self-defense or this occupation is about self-defense, what we saw in the wall advisory opinion was the majority said, well, Israel can't claim a right of self-defense when facing attacks by terrorist groups or which originate from territory over which Israel had some control. So this view that self-defense is unavailable in response to threats posed by terrorist groups is inconsistent with the UN Charter. It is also inconsistent with the experience of many governments worldwide. The stakes are actually quite high on this. Since 1970, there have been over 200,000 terrorist attacks by non-state actors perpetrated worldwide. Over 200,000 terrorist attacks. Many of the largest such attacks occurred in and were largely organized from areas over which the attacked nation had control. These include, for example, the 2017 London Bridge and Manchester Arena terrorist attacks that killed over 24 British civilians. There were also terrorist attacks, obviously against the US on September 11th, but also the November 2015 terrorist attacks that killed 130 civilians in Paris, the Mumbai, Jaipur, and Ahmedabad attacks that killed hundreds of Indian civilians. It seems to me that the American, French, British, and Indian governments want to make sure that the pending ICJ case does not entrench or expand upon the self-defense restrictions in the Wall case. So these are reasons why the UK, in and of itself, should be motivated to robustly engage in this case, because it does not want to create a situation where the International Court of Justice is saying that states can only exercise defense against state actors and not by non-state actors, because Britain wants to be able to exercise self-defense against non-state actors, and Britain has been subjected to attacks by non-state actors. So that's an example. Obviously, also, the UK is concerned by the advisory opinion authority being used to circumvent sovereignty. The UK, in the Chagos case, I think it was, and in various other ways, there have been efforts to basically bring cases contrary to UK interests through the advisory opinion mechanism. And the UK and the US want to shut that down. And so that is why you see the UK, according to The Guardian, having said, no, we can't be in the business of allowing advisory opinions to circumvent the sovereign right of states to determine whether to submit to the court a particular dispute to which they're a party. So again, this, you can remind the UK government, whether or not you like I wouldn't put it this way, but basically the message is, whether or not you like the Israeli government, you have interests in this case as well.
And it's worth stressing that rather than seeking to shut processes of the court down, that's about seeking to make sure that the ICJ adheres to its own powers and its statutes and the founding purposes. So certainly. Orde, since we all anticipate that the ICJ is likely to give a substantive opinion, a couple of questioners ask about the substantive arguments that lawyers or interested individuals may be able to persuade states to advance. You've mentioned, of course, that the responses by states to those submissions already put before the court are due the middle of next month. We've had a couple of questions in particular on the legal rule of uti possidetis juris, and also the way in which the mandate features into the legal framework that must surely underpin the questions that the court is about to consider. Do you have any points to raise on the substantive arguments that might be key to persuade states to pursue?
I know that there are folks who are sort of very fond of making some of these uti possidetis arguments and such. I don't know that they're the key winning arguments here. It seems to me that there is probably a consensus among the judges in the court that Israel's presence in the territories is justified as a temporary measure based on self-defense. I don't know that trying to make the argument that Israel has the right to permanent ownership of the territories is going to be particularly successful. I think that, as I understand it, the argument is really about whether Israel's previously legal occupation of the West Bank has become illegal, right? The other side is arguing that it has become illegal. But this is contrary to, first of all, the Land for Peace legal framework established by Security Council resolution, the Oslo Accords, and it's also contrary to the law of armed conflict governing belligerent occupation by parties to a conflict. And that, it seems to me, is where the battle is going to be fought along those lines in the law of occupation. I mean, you know, I like being right, but I also like winning. And I'm all about figuring out where the battle lines are, where things could be shifted. I don't know that you're going to see a court decision all of a sudden that Israel basically has a right to permanent ownership of the territories. I think that's not going to happen. What you're going to have is either an opinion that Israel's presence in the territories has become illegal, or that Israel's presence is still legal, but it needs to stop taking steps that look like creeping annexation. I think that's what you're down to in this case. And so I'm focusing on making the argument that Israel's occupation continues to be legal, and that you know, that it's legal per the Land for Peace legal framework and LOAC, and that if Israel is doing things which are perceived to violate the law of armed conflict, then Israel needs to stop those steps. But the punishment for Israel doing, you know, things which are perceived to violate, such as the wall and the settlements, etc., isn't that Israel needs to unilaterally withdraw right now. I mean, I think that's where the battle lines are.
But it seems like you're suggesting that the Overton window of what will be taken seriously as an argument has already been shifting. But I do appreciate, and certainly from some of the questions, that there are those who will say that, especially in the context of these discussions and these fora, the arguments for the equal application of international law and key principles or rules, customary rules, and their equal application are pretty critical to make. And of course, that does turn the framework of the terminology that you've been using, occupation and annexation, very much on its head. But I appreciate what you say. Don't be right to be clever. But so we'll see what arguments the court is willing to entertain. Important, though, that the other analyses of international law don't fall by the wayside because, unfortunately, of the sort of uneven playing field that Israel is having to grapple with. A couple of questions actually on the issue of Ukraine, if I could pick up on those. One question asked, could a theme in defense of Israel's position in this opinion be the ICJ's recent decisions in favor of Ukraine militant? Forgive me, in those questions, decisions in favor of Ukraine militate in favor of supporting Israel's position, because in Ukraine's cases, a theme is that ethnic ties to a territory do not grant sovereign territorial ties, and here too, ethnic, cultural, and historic ties that the Palestinians have claimed in the West Bank cannot dictate the allocation of sovereign rights, as you've indicated that the framework for that is negotiation with Israel. And as a follow-up, also related to Ukraine, a question of whether we know if the US, Israel, or advocacy groups are reaching out to Ukraine or other governments to weigh in favorably for Israel.
So I'll take the second one first. It's worth noting, I mean, Ukraine has waged a fairly effective and sophisticated lawfare campaign on its behalf. In terms of whether there's an effort to get, I know that considerable efforts were made vis-a-vis this case. I think the biggest diplomatic effort that was made was to try to defeat the resolution in the UN General Assembly. There was a very large-scale effort led by the United States to try to defeat the original resolution in the General Assembly. requesting the ICJ to take on this case. The effort almost succeeded. It did not succeed. I think that my concern is that so much effort was put into that. We want to make sure that that didn't, shall we say, take up all the oxygen. The effort failed. There's a case now, and there needs to be an effort to line up favorable submissions in this next round. The challenge is that the only countries that can submit in this October 25th round are those that submitted in the July 25th round. And there are a limited number of friendly countries that, find the list on the ICJ website. There are a limited number of friendly countries that weighed in. I'm just skimming. I don't actually see Ukraine on the list as having weighed in. I don't know. Jonathan says Ukraine did not make a submission. I think the countries that are going to be really key in this next round are, Canada, France, the United Kingdom, Japan, and a few others. And it seems to me that it's, you always try to figure out what's the most efficient use of your resources. And I think rather than trying to, persuade countries that are maybe disinclined, I think the pro-Israel communities, the best investment is to focus on the key countries that have already shown they are inclined to do the right thing and encourage them to ramp up their efforts. Again, that would be the UK, Canada, probably France, the US, and some others, with an emphasis on the 8 countries that have judges. Again, I'm all about sort of focusing in. What is the leverage here? What is the point where you can most efficiently push to make a difference?
Zooming out then, perhaps in terms of relationships with the states, what would you see as the relationship, if any, between this case and regional developments? For example, the Israeli-Saudi negotiations.
Yeah, so look, I mean, my sense is that this case is probably, the efforts by the Palestinians and their allies are probably to some degree driven by fear of the Israeli-Saudi peace negotiations. There's been a lot of talk that the Saudis might, shall we say, not emphasize Palestinian interests as the Saudis make peace with Israel, and that if the Saudis make peace with Israel and other Arab and Muslim countries follow, that will mean less leverage for the Palestinians. So the Palestinians, this is maybe a way of derailing some of the normalization by finding yet another issue to beat Israel up with, and to be able to say to the Saudis, depending on the timing here, look, Israel is in violation of the ICJ here and in violation of the ICJ. How can you be making peace with those people? So it's a bit of a spoiler play, I think, the effort to get this ICJ decision.
That takes me perhaps on to a question that's been asked on what the risk of enforcement of an ICJ decision is. And it might be worth my including an anecdote that about 4 or 5 months ago, I was watching a UN conference on legal issues pertaining to Israel and the Palestinians, where many of the contributors and presenters were lamenting their failed efforts to get the term of apartheid to stick vis-a-vis Israel. But the the reassurance was given that the reason for that is because up until now they haven't had a legal opinion justifying the use of the term against Israel, but not to worry. They anticipated one would be forthcoming in the context of the ICJ advisory opinion. So with that, perhaps hope that's been expressed by those actors at the United Nations targeting Israel, what would you think of the risk of enforcement or the follow-on effects, perhaps, of an ICJ decision or opinion in this case?
So that's a really good question. I would say that I would be surprised if the ICJ comes out and makes a decision that Israel is engaged in apartheid behavior. I think the Palestinians would very much like the ICJ to come out with that. I would say that the ICJ is unlikely to do it based on what I've seen. I would say that is the worst case scenario. I think if you, if you had a 14-1 vote of the ICJ that Israel is engaged in apartheid activity, that would be disastrous for Israel. I mean, it would really turbocharge BDS, right? I mean, obviously the ICJ does not have its own troops. It can't directly enforce things. What the ICJ is seen as is perhaps the ultimate arbiter of what is the state, what is the content of international law. And I think they probably won't state that Israel is engaged in apartheid. I think there's a very strong chance that they will say that Israel's occupation has become illegal and Israel must withdraw. Like I said, that, they're not going to be able to force Israel out at the point of a gun, but they are going to, it's going to turbocharge BDS, which, and as we've seen, the UN Human Rights Council has the ability to not enforce, but certainly push BDS forward by announcing that certain companies are engaged in activities in the occupied territories, et cetera. It'd be much easier to greatly expand that list if the only test is whether the companies are involved in any way in the occupied territories, right? Previously, the argument really needed to be that they were involved in illegal activities in the occupied territory, involved with the settlements or involved with the fence. Now, if the entire occupation is ruled as illegal, I suppose any Israeli company with any presence in the occupied territories can be seen as in violation of international law. So that BDS list could grow considerably. And I think that plus the impact on Palestinians who might be inclined to compromise for peace are probably the biggest negative aspects here. Like I said, the ICJ can't enforce directly, but malevolent actors can make a lot of hay out of its decisions.
What you're describing is really a vicious circle, where the UN Human Rights Council is generating material which it puts before the court, seeking to influence those so-called legal conclusions, and then uses those legal conclusions to generate even more material.
That's exactly what they're doing.
May I ask about the flip side of this? And that one questioner asks, what will the implications be in the event that Israel wins? I know you've talked about this case being winnable. So if we're adopting that particular terminology, what would you see the impact as being?
Sure. I think if you were, what would a win look like? A win would either be an 8-7 decision. I don't see that the ICJ is going to reverse its 2004 wall decision. It's not going to turn around and say, oh, well, actually the settlements are legal and the wall is legal. But one could envision the ICJ basically saying that, the occupation is not itself illegal. And that what Israel needs to do is, to the extent Israel is violating the law of armed conflict through the settlements or through the wall, that Israel needs to dismantle those, but the occupation itself is not illegal. That's probably the best case scenario coming out of this case, would be an 8-7 I would say that, how likely is that? It's hard to say. I would say from the perspective of, Israel advocates, the worst case scenario in this case is like a 14-1 defeat, as in the wall case. You want to at least make sure that if you lose, there are several countries on your side. Otherwise, it looks just like, it becomes very difficult to argue in international legal circles that the settlements are legal, or that the wall is legal, when you basically have a 14-1 case against you of the ICJ. It certainly muddies the waters if it's an 8-7 or 7-8 or something like that. So I think that's what we're talking about in terms of what would be a quote unquote victory.
Orde, thank you so very much for all of your insights. It certainly will muddy the waters and stack the decks, but recourse to basic legal principles and solid arguments in international law are nevertheless so extremely important. Thank you for all of your efforts and initiatives, especially as far as the ICJ is concerned. I know that UKLFI have been very heavily involved in preparing submissions on this also. And I know that our audience, we haven't unfortunately been able to get through all of the questions, but a good number of them. I know our audience are likewise deeply concerned and very engaged. So I'm very grateful for you taking the time.
Sure. Thank you all. And, if there's anyone who's interested in learning more about this case, feel free to reach out to me. And, I encourage folks to write about this. This case has largely gone under the radar. I think it's a very dangerous case, and the more light that is shed on it by our side, it seems to me, the better. So hopefully this contributed to that and to inspiring others to write about it as well.
Thank you. And
Thank you. Shana Tova.